Hello Sheila, hello Shubham, hello Kriti.
Hi, Dr. Galgali, we have joined.
I know, yeah, I'm still in the car. I'm just 5 minutes away from home. I think I'll put on my camera as soon as I reach home. Just five
Okay,
minutes away.
no problem.
Yeah. Hello Sushma. Hello
Very
Shamik.
good evening. Very good evening, Preeti Madam. Very good evening to the team, Dr. Sheila, Dr. Neelam, Dr. Avinash Bansal sir for joining. Welcome, Dr. Latika Balla. Hi, Sheila.
Hi, ma'am. Good evening.
Anji, good morning.
Yeah,
Good morning.
very
Good
good.
evening, ma'am.
Very good evening. Very good evening.
Thank
Um,
you
uh,
for having us.
Actually, we extend our sincerest appreciation for your, so much insightful webinar series, collaborating with THA for this series. Thank you so much, Shaila.
That's fine,
Uh,
ma'am. It's our
Ma'am, all
pleasure.
the best and congratulations for being the CHA president. I was not in Pedicon. I could meet you. So I will definitely, whenever we have a next thing, we'll come and meet you, ma'am.
Thank you so much, Latika ji, and I always count you in my team. So we
Yeah.
are having a lot of activities and projects. So you will definitely be there with us, and looking forward to having the collaboration with the Delhi team, particularly you and Dr. Deepa and other people.
Yeah. Most welcome, ma'am. Most welcome, ma'am. Yeah.
Very, very good evening. This is Dr. Shamik Ghosh. I'm the secretary of the CHA. And
Welcome, Dr.
thanks a
Shamik.
ton. Yeah, thanks a ton for this. I mean, as adolescent practitioners, this is something we look forward to, continues to confuse us in critical situations. So hopefully we'll learn a lot today.
Yes,
Yeah,
thank
Dr.
you, doc.
Shashadri, he's an excellent person to talk about and
Yeah.
Right.
deliberate.
We look
And
forward to a great, yeah.
we
And we
had
have joined
attended.
as a great team, yeah. So I think we all are looking for this is a unique webinar series, Latika ji, and that is why I am so very thankful to Dr. Preeti Glagali, madam, for facilitating and coordinating this
Yeah.
webinar.
So uh, last year also they had these counseling seminars for how to look after the POCSO patients. So that was also very extensive and very practical and very patient oriented
Shakti, yeah, that was
how
Shakti, yeah.
to be, yeah. So last time, and Dr. Hema Bindu also, she has been always in forefront, and now we just look forward to you for being there
That
and
is AHA
doing.
legacy, right, Latika ji? You
uh,
all are so active and dynamic.
So actually, it is still, I think, coming to AdolesCon is always like meeting up a family, not
True,
like going to any other place. It's like, you are meeting all the members, just like your
mm.
family, you meet up everyone over there. I think
True,
Dr.
true.
Kiran
That's
Agarwal had joined.
ma'am, welcome, Kiran ma'am. Dr. Deepak Gautam has joined. Dr. Deepak ji, welcome.
हाँ जी गुड
Very good
इवनिंग
evening, sir.
Good evening,
Dr.
Dr.
Deepak
Deepak. Congratulations.
मैम गुड इवनिंग मैम गुड इवनिंग डॉक्टर लतिका डॉक्टर
Uh,
गुड इवनिंग
Hanji.
डॉक्टर शमीक
Very good evening, Dr.
very
Deepak. So
warm
nice to see you.
welcome to Dr. Shekhar Sheshadri, sir.
गुड
Sir, very
इवनिंग
warm
डॉक्टर किरण
welcome and good
डॉक्टर
evening.
अग्रवाल डॉक्टर प्रीति मैम गुड इवनिंग
Dr. Shekhar, sir, has joined. Sir, very good evening and warm welcome, sir.
Thank you.
Very good evening, sir.
Sir, we are truly thrilled to see you once again on a familiar platform. And we look forward to having a great session under you, sir. Thank you so much,
Thank
sir.
you.
Preeti ma'am, we will start within 5 minutes time, right? Preeti ma'am? Shaila?
Yes, ma'am. I think we can start in 5 minutes.
Right, in 5
Shubham, you
minutes.
want to
Sir
check
has
the
also joined.
slides?
Yeah, by then we must check the slides. Yeah, please.
Yeah, I think we have about 13 people, that's excluding us. So I'm guessing we'll wait a few minutes and hope that more people will join
Right.
and start.
Welcome, Dr. Hima ji.
Yeah, good evening. Thank you,
Very good
Sushma. It's a great
evening.
initiative.
Very good evening.
Good evening, ma'am.
Good evening,
Good
ma'am.
evening.
Dr.
Good
Himabindu,
evening.
ma'am.
Hi, good evening, Dr. Deepak, Dr. Shamik, and all. Nice to see all of you.
Good evening, Dr. Kiran.
Hi, good evening. Good evening.
And ma'am,
How are you?
very happy to see you, ma'am.
Shekharji, good evening. Good evening, all.
Good evening, Dr. Shekhar Sheshadri ji.
Hi, Hima.
Hi, madam.
Hi.
Yeah, Shubham, your screen is visible.
Hello.
I think Dr. Shamik, we should start at time because it's such a topic, it will take long to end.
Sir, 2 minutes
Yeah,
more.
true.
We will
No,
start
no,
sharp at
we
8.
can wait for 5 minutes, but
Yeah, no, we
as
will
early
start
as
sharp
possible.
at 8, sir.
We'll
We
start
have
sharp. We'll start sharp. Yeah.
Because बाद में हमारे कंट्रोल में नहीं रहेगा टाइम. So
नहीं
many
नहीं ऐसा
queries.
नहीं होगा ऐसा नहीं होगा ऐसा
Such
नहीं
an
होगा
interesting topic
2026 will
and
not be
such a
like that.
learned faculty. मतलब
I know
ऐसी अपॉर्चुनिटी कम ही मिलती है ना लोगों को.
कभी मिलती है सही बात है नहीं लेकिन हम लोग सर शार्प 8 बजे चालू करेंगे अभी थोड़ी सी टाइम है ना
जी मैम.
Hello, Kavita.
Hello, ma'am. Good to see you all after so many days.
Very good
Yes.
evening, Dr. Kavita.
Hello, ma'am.
Good evening, sir. Good evening, ma'am. Good evening, everyone.
Nice to see you all.
Same here, ma'am.
Yeah.
So still, I'm not able to.
Good evening, ma'am. Good evening, all.
Good evening,
Hello, Shamik.
sir.
Hello, sir. Hello, sir.
How are you?
I am fine.
Good evening, Dr. Preeti, Dr. Kavita, Arvind ji, everybody. Good evening.
वेलकम
Hello,
डॉक्टर
Pindu.
Sheila, can we stop sharing for a while so that we can see how many people have joined and who all are there? Thank you so much.
35.
35.
Around
35.
35 ma'am. 35 exact, including us.
2 minutes है.
Yeah, 2 minutes hai, ma'am.
Good evening, Dr. Geeta Patel.
Good evening, sir. Good evening.
Very good
Very
evening, ma'am.
good evening
Good
and
evening, sir.
welcome
Good
you
evening.
all.
Good
Good
evening.
evening, Maji.
Good evening.
Hema
Good evening,
Bindu.
Gita ji. Good evening, Banga sir.
Good evening.
Banga sir has joined. Great.
जी
Good evening, Preeti and Dr. Shekhar Sheshadri, sir.
Evening. Good evening.
Good evening, everybody.
Good evening, Dr. Geeta. Good evening, madam.
Good evening, Hema Bindu.
Good evening.
$38.
Shamik, I think you can start.
Yes,
Yeah,
ma'am.
it is sharp 8 and you can start now.
Yeah.
So, a very, very, very warm welcome from the IAP Adolescent Health Academy. We are the largest subchapter of the Indian Academy of Pediatrics, and it is my absolute pleasure and privilege that today, with the Azim Premji Foundation, which has amongst many of its host, can you please mute everyone? Right. So it's absolutely a pleasure and a privilege that today we've joined hands with the Azim Premji Foundation, who has, amongst its many preeminent faculties, also Dr. Shekhar Sheshadri. Welcome, sir. And we are really looking forward to today because, as adolescent healthcare practitioners, I think so. One of the most difficult paths to navigate is one of underage pregnancies. All of us have had this kind of a situation, and we really haven't known what really to do, how to navigate, and how to reach a logical conclusion. May I please call upon my very esteemed chairperson, Dr. Shushma Desai, ma'am, to share her thoughts, and then we can proceed.
Thank you, Dr. Shamik ji, for starting the session. On behalf of very good evening, on behalf of Adolescent Health Academy, I extend my warm welcome to the esteemed guest, distinguished speakers, Dr. Shekhar Shesadri sir and his team. On behalf of AHA, I extend my sincere thanks to Dr. Preeti Galagali madam for facilitating and coordinating this webinar series. This is going to be a unique webinar series, friends. We all know that adolescence is a unique phase in itself. Apart from the various physical, mental, psychosocial, behavioral development, there is a unique development which takes place only during the adolescence, and that is sexual and reproductive health development.
Recording in record.
With the characteristic risk-taking behavioral pattern under the hormonal surge, tendency to experiment with the sexuality, the adolescent often land up with serious complications like underage pregnancy. There is, to some extent, the early marriage is also contributory to underage pregnancy. But as we all know, apart from serious medical and health-related issues, the underage pregnancy is attached to medical legal aspects as well. If we look at the Indian statistics, up to 7% of girls between the age of 15 to 19 become pregnant, and quite a big number of girls before the age of 18 get married, despite all those, child marriage acts and everything. So these all are the contributory factors. But the serious problem is Underage pregnancy sits at a complex intersection of healthcare, law, ethics, and the child protection. While mandatory reporting provisions are designed to safeguard the minors, we, the healthcare providers, often face real dilemmas in ensuring confidential, compassionate, and lawful care, especially within the framework of the MTP Act. Navigating this overlapping responsibility is not always straightforward, and clarity is essential. So, from the webinar series, which is beginning from today, we are going to get enlightened with all the details of the medico-legal aspects of the adolescent, reproductive, and sexual health care practices. Without taking much time, I once again extend my warm welcome to Dr. Shekhar Sheshadri sir and the team and request them to begin with the webinar. Before that, I will request Dr. Shamik Ghosh, the Secretary of Adolescent Health Academy, to please take the other proceedings. Thank you so much for being with us. Thank you very much.
Thank you so much, ma'am. Thank you so much for that very elaborate and yet very kind words and very brief words. Thank you, sir, ma'am. We now move on to, it's now my absolute pleasure and privilege to introduce a friend, a philosopher, a guide, and somebody who needs no introduction to the Adolescent Health Academy family and who has very promptly pioneered this partnership with the Azim Premji Foundation. I am talking of none other than Dr. Preeti Galgali. Very warm welcome to you, ma'am. You are one of the very first pediatricians who has been a pioneer in comprehensive adolescent healthcare in our country. The list of positions of responsibility which you have held and discharged is endless, and probably it will take up a lot of time. Currently, she is the Vice President, the South Asia International Association of Adolescent Health. She's co-authored the first IAP Adolescent Practice, Digital Wellness and Child Protection Guidelines. As chairperson of the AHA in 2019, she launched the AHA website and the Indian Journal of Adolescent Medicine, the Teen Suicide Prevention Program. So, Dr. Preeti Galgali, thank you so much for having taken this initiative, because spreading this knowledge is of paramount importance to the practicing adolescent health practitioner. Over to you, Dr. Preeti Galgali.
Thank you so much, Dr. Shamik. Good evening to everybody. It is a pleasure to be here today amongst all of you and amongst my very favorite mental health professionals. I can say that Dr. Shekhar Sheshadri, Dr. Sheila Ramaswamy, Saurabh, and Shubham. So it's an absolute pleasure here. And as India launches a renewed focus on mental health, as menstrual health becomes a fundamental right, and also many girls go missing in Mumbai over the past few days. So there are a lot of concerns about adolescent reproductive and sexual health. It is said that alone we can do so little, together we can do so much. So this is what this platform signifies. We as pediatricians joining hands with mental health professionals and also lawyers and also other disciplines to ensure adolescent reproductive and sexual health rights. So we have a great team from Azim Premji Foundation who is going to be holding and conducting these webinars, which I'm sure will be very useful in clinical practice. We have Dr. Shekhar Sheshadri, who is the Professor Health, Dr. Sheila Ramaswamy, who is the Leader Health, and Shubham and Saurabh, who are lawyers, and they are facilitators in the health and policy. We all know that Dr. Sheila Ramaswamy and Dr. Shekhar Sheshadri initiated Samvad. It was the Government of India initiative, an integrated initiative for mental health and child protection, and they are carrying on this work forward now too. So we look forward to listening to them. It's over to you, Dr. Sheila Ramaswamy.
Thank you very much for that kind introduction, Dr. Galgali, Dr. Sushma Desai, Dr. Shamik Ghosh. It's a real pleasure to be with you all this evening. It's always an honor to be with IAP and the Adolescent chapter. I believe Dr. Shekhar has a few opening remarks to make to provide an overview of what we're going to talk about this evening, and then we will proceed. Dr. Shekhar?
Thank you. Thank you very much. In response to Dr. Parveen's comment on chat that there is a sound of a bell ringing repeatedly, and Dr. Kiran Makhija's response to that to say that that announces every new person who is joining on chat. We will have to bear with this background music of the bell as we proceed in this session today. Friends, I just want to tell you that at the current point of time, with Sheila, Saurabh, and Shubham, I am in the process of intervening in the present proceedings in the Nipun Saxena versus Union of India and others, uh, a case that is going on in the Honorable Supreme Court. And I have already filed an interim affidavit on this contentious issue. Now, the the matter involves the pivotal question as to whether, reducing the age of consent from 18 to 16, or alternatively including what is called as the close in age exception to culpability, would protect adolescents from the clasps of the law for engaging in activity that is a product of their neurobiological maturation, normative development, and social environmental influences without alienating the protective agenda of the POCSO Act 2012. Now, having been on the drafting committee of POCSO before it came into existence in 2012, I would like to say that a lot of the issues that is facing us today, particularly this age of consent and also the contentious issues of mandatory reporting, was not what we had included as the drafting committee. So, what we are trying to do is essentially to, kind of point out the issues that are involved in this whole business of adolescent sexuality, in terms of health, in terms of legal implications, and so on. So, if you really want to understand the interplay between adolescent neurodevelopment, normative sexual development trajectories, and life skills deficit, this is really the crux of what practicing pediatricians who have deep interest in adolescent health really need to address to. So what we have done is that we have tried to point out the relationship between adolescent development and sexual decision making. We have tried to look at other influences on normative adolescent sexual development. And while neurodevelopment is a key driver of high-risk behaviors and so on, implying thereby that social and environmental determinants of adolescent behavior need to be given due consideration to understand how adolescents actually make decisions, particularly sexual decision making. There is also the issue of life skills deficits and the lack of knowledge and skills in adolescents to navigate sexual relationships, to navigate indeed decision making, which really requires the execution of a complex set of socio-emotional behaviors and skills. And these include gender dynamics. It includes arousal. It includes what you consider as at risk and so on. So this is the kind of frame of reference that I wanted to present so that when we really look at capacitating medical and health centers to provide adolescent sexual and reproductive health services, the question we need to ask ourselves is, are those services, sexuality and life skill education interventions, reproductive health services, uh, and the whole mandatory reporting dilemma, are these all developed in a robust way where pediatric practice, particularly where adolescent health is concerned, has it really developed? So this is really the basis on which we're going to be addressing the contentious and worrying issue of underage pregnancies and reconciling the mandatory reporting obligations of the POCSO Act 2012 with the MTP Act of 1971. And on behalf of my colleagues, Shubham, Saurabh, and Sheila, from the Azim Premji Foundation, we are very happy that the Adolescent Health Academy of IAP has really invited us to do this session for you. So what we're going to do is we're going to spend the next 35 to 40 minutes to actually taking you through this issue of reconciling mandatory reporting with the MTP Act. And then we will have some time left at the end for issues that you'd like to put. And Dr. Preeti Galagali will curate the questions which you can put on chat. I see that the numbers who've joined the session have crossed a century. That's very heartening that there is deep interest in this subject. So, given the time that we have, at least in this session, we will try and cover as many issues that you wish to raise after we share with you the substantive part of the issue at hand. And Preeti will basically curate. If there's anything left unaddressed, we will see how we can look at it in future sessions. So this is the background and context. I now I would request my team to basically start the session. Thank you.
Thanks, Dr. Shekhar. Shubham, before we begin, as there are many requests, is there any way to stop the bell, or we have no control over this? Is this a Zoom feature?
I don't.
Okay.
But I'm making Saurabh the host so that Saurabh can try at the back end in case it's possible.
Okay.
Can I have another request? I mean, can you mute all others except the speakers?
Ma'am, no, if people want to unmute, they can unmute in this session.
Uh,
Therefore, I was about to request everyone to be a little mindful about whether I know that it's late at night and you might be late in the evening and you might have like other errands to run and while you're attending this webinar. But I sincerely request you to be a little mindful of whether you're on mute or not, to be always aware and cautious about that. So because it becomes very difficult for us to present, facilitate, and mute every person for every 2 to 3 seconds, right? So therefore, it's my humble request that everyone keeps is a little more cautious about whether they are on mute or not. With that said, Saurav, I've given you the controls for in order to check if it's possible to stop the chiming noise for people to join when people join. But without losing any time, let's move forward with the session. Thank you, Dr. Seshadri, for that enlightened introduction to what we what we want to achieve and what we want to do in this session and setting the agenda for the remainder of the evening. When we talk about the POCSO Act, it's very essential for us to recognize the fact that the POCSO Act is not just a law which has the law enforcement and the judiciary at its core, but it also places various child-facing stakeholders, including doctors and medical professionals, at the very heart of the implementation of the Act. Therefore, it becomes very important to understand and recognize the various nuances that are there legally within the POCSO Act in order to both contextualize the work that you do with children and adolescents, and at the same time also know various enablements and as well as constraints that the law puts on your practice and on your duties that you fulfill in your clinics and in your institutions, right? So therefore, it's important to recognize recognize the limits of the law as well as the enablements of the law in order to better orient your work towards the needs of the child or the adolescent, right? One second, trying to mute somebody. Okay. Now, let's start with the aims and objectives of the POCSO Act before we move on to the main agenda of the session, right? Because it's important to just know where we are, what we are operating with in order to get a better understanding of things like mandatory reporting and adolescent sexual consent. So when we look at the aims and objectives of the POCSO Act, we see that the act is not just an act which is set out to protect children from sexual assault, abuse, and harassment, but at the same time, it is also an act which has various different kinds of punishments for different kinds of sexual offenses that are committed against children. At the same time, it also establishes certain child-friendly procedures both in the courtroom and outside the courtroom, in the police station and in hospitals and clinics as well, in order to enable the child victim to get better support during the whole process of the law as it takes place, right? And last but not the least, the POCSO Act also goes ahead and ensures that the right to privacy and safety of the child is maintained at all stages throughout the whole legal process for the child, and that will become increasingly important as we move forward in this session and start to also discuss the limits of mandatory reporting under the POCSO Act, right? Now, if we look at the key provisions of the POCSO Act, the first thing we need to recognize is that the POCSO Act does not categorize children into different categories based on age. What the Act says is that any person who is below the age of 18 is considered a child. And although there are different laws in this country which recognize the age of maturity or the age of who is a child and who is an adult in various different as various different ages, that is not something which is true for the POCSO Act, and it has one blanket marker which is 18, and anything beyond 18 is not anyone beyond 18 is not considered to be a child, right? The second very important and unique feature of the POCSO Act is that the POCSO Act is the only act which deals with sexual abuse which is gender neutral in nature. What I mean by that is that both boys and girls can be victims under the POCSO Act, and at the same time, the offender can be both a man or a woman in the case of the POCSO Act, right? So it is gender agnostic, unlike the IPC or the Bharatiya Nyaya Sanhita, which is very gendered in its implementation of recognizing only women as victims and only women as victims and men as perpetrators, right? The next thing which is very important when we talk about the POCSO is that it criminalizes all kinds of sexual activity with children, including consensual activity that adolescents who are also children under the Act might participate in, something that Sir alluded to earlier, and what we will be talking about in greater length in the subsequent parts of the session. Apart from that, we also the Act also recognizes the fact that when there is when there is two adolescents who engage in or two children who engage in sexual acts, we do see the age gap between the child because that indicates if there can be harassment or grooming or some form of manipulation, and therefore the age gap matters. However, there are a lot of cases wherein the age gap is very minimal, and in those cases and there is implicit factual consent between the both parties, and in those cases we'll be talking about how the law has seen those cases and how we hope it will change in the near future for the better of adolescents around the country, right? The last but not the least, what we also need to recognize is that there are four main types of offenses under the POCSO Act. It is not just limited to penetrative sexual assault, which is the insertion of any body part or any object into any of the orifices of the child. It is beyond that. That is one kind of sexual abuse, but beyond that, other forms of sexual assault, which can be physical but not penetrative, are also recognized under the Act. Similarly, non-physical forms of sexual acts, including verbal sexual acts and non-verbal sexual acts, are also recognized, and or digital sexual acts are also recognized under the POCSO Act in the form of sexual harassment. And last but not the least, using a child for pornographic purposes or storing child pornography in your own devices is also something that is considered to be an offense under the POCSO Act. These are some major stakeholders which are recognized within the POCSO Act. Please note that medical professionals are one of the key stakeholders within the whole ambit of the POCSO Act and its implementation, and therefore it is important that you recognize what the law says about sexual assault when you deal with children, particularly who have come in order to access reproductive health care in your clinics and in your setups. This is the broad flowchart in terms of how a POCSO trial proceeds. It starts with the first information report or the FIR, followed by the medical examination. Then you have the recording of the statement before the magistrate, then the production of the child before the CWC, then other investigative procedures like site identification, etc., which are not very important wherein your roles are concerned. But there is the recording of statements of witnesses by police, which can include medical professionals, in particularly when they have conducted certain medical examination on the child, or if the child has sought some form of treatment with the medical professionals, which concerns with the sexual act concern, and also if the medical professional is the first level responder or the first responder in this case, right? Then you have the filing of the charge sheet, then you have the framing of the charges, then the child's testimony is taken, when the trial begins, and then the child's testimony is taken, rest of the prosecution evidence is provided, then the defense evidence is provided, then you have the statement of the accused, which is taken, and then finally you have the final arguments. And once the guilt is attributed, whether the accused is guilty or not, and if the accused is found guilty, the judge then goes ahead and sentences the accused to a particular sentence in prison, and along with some form of compensation or along with some form of fine. And last but not the least, the final compensation is paid to the victim, right? Ideally, all of this happens within a year from the date of the reporting of the offense itself. However, it is I use the word ideal very consciously, because you will not find always that these trials are concluded within a year. Sometimes they take more than a year, in fact, in order for these trials to be concluded. And that is largely a part and parcel of how the judicial system works. Because of huge pendencies, we might see that these trials sometimes take longer than a year, but the best effort is there's a lot of effort put in order to conclude this trial within a year, right? There are three. So since we have now an introduction or a brief orientation on what the POCSO Act says, there are three major issues that we wish to discuss during the course of this presentation. The first is pertaining to mandatory reporting. The second is adolescent sexual consent and how the POCSO Act deals with adolescent sexual consent. And last but not the least, we go ahead and talk about the medical termination of pregnancy, i.e. abortions, and how the Medical Termination of Pregnancy Act 1971 interplays with the POCSO Act in order to ensure reproductive health care for children and adolescents. So let's start with mandatory reporting, right? Now, what is mandatory reporting? Mandatory reporting essentially is a very special feature of the POCSO Act, which is not always present in other legislations or other criminal legislations, primarily because mandatory reporting is a feature which places the burden on somebody who has information or who suspects that there is sexual abuse present to go ahead and report this offense or report this of the knowledge report this offense based on their knowledge or based on their suspicion to the police or the special juvenile police unit or the child welfare committee. However, please bear in mind that the mandatory reporting clause, which is section 19 under the POCSO Act, does not mention that there is any particular time frame for reporting of offenses. Why do we think that this is important? It's because of the fact that mandatory reporting, often when we hear that there is a clause like mandatory reporting and the failure to report is something that can be penalized by the law, then there is a tendency, especially amongst us who are typically first level responders, to go ahead and without any delay immediately go ahead and report, like immediately as soon as the child says, within 24 hours you go to the police station and get the offense reported, right? However, the POCSO Act does not actually prescribe any such time frame, and therefore this becomes important as we later deal with our methodology, our 8-step methodology on how to go about ensuring a child-centered participatory reporting process. We will see that instead of thinking of it as a one-off event which happens immediately after the child discloses abuse to you, it should be taken more as a process which is long-term and might take more than 24 hours, more than a few days, or more than a few sittings in order to enable the child to go ahead and report confidently to the police and other concerned authorities such as the child welfare committee, right? So therefore, that's very important to note, and hence please bear in mind that there is no pressing time limit when we discuss mandatory reporting under the POCSO Act, right? The second thing that we need to remember is that mandatory reporting does not have retrospective application, which means that for all cases which have happened before the 14th of November 2012, the mandatory reporting clause does not kick in because the POCSO Act was enacted on the 14th of November 2012. So all offenses pertaining to child sexual abuse earlier than 14th of November 2012 are not within the ambit of the mandatory reporting clause under the POCSO Act. Equally important, it is also for us to recognize that, and this is something that we have had extensive discussions with judicial officers and judges of the High Court about, is the fact that mandatory reporting is also something not which is a prerogative if the victim today is an adult but was a child when the offense took place. So, for example, if there is a 16 or a 17-year-old who discloses to you as a 20-year-old or as a 19-year-old or as an 18-year-old that they have been sexually abused when they were a child, since they are now an adult, the mandatory reporting obligation no longer exists with the responder when such disclosure is being made, right? So please bear that in mind, because we have seen in certain institutions across the country that the very fact that someone might have had like a sexual experience 10 years down before, and in the history taking during normal ANC procedures, they were found to have that pregnancy 10 years back when they were 16 or they were 15, then that case is simultaneously reported to the police. Please note that that is not acceptable within the ambit of the law, and no such reporting needs to take place, particularly if the victim today is an adult, right? Saurabh, if you would like to continue from here.
Yeah, thanks, Shubham. And hopefully I'm audible to everyone. I'll just proceed now with a few cases. I think Shubham has taken us through the POCSO framework. What are the key parts of the act that are relevant from all of your perspectives, right? And specifically, what does the law on mandatory reporting say, which is the subject of our workshop and session today, right? So we have the law on one part, which, as you can see, is worded in ways that can seem broad, and that's also led to some amount of confusion, which is why there have also been cases that have made it, as you can see now, all the way to the Supreme Court to address some of these areas of ambiguity. So I'll just briefly take you all through a few cases that give us some certainty with regard to what are the key things we need to keep in mind when it comes to mandatory reporting, right? And this is specifically in relation to medical professionals such as yourselves. The first case I want to discuss is the case of Dr. Sister Tessie Jose versus the state of Kerala. This was a Supreme Court case in 2018, right? And if you look at the key highlighted parts, what it effectively says is that there is no burden on you as a pediatrician or as a medical professional to conduct any kind of first level inquiry or to perform any kind of investigative function on your own, right? There is absolutely no legal requirement for you to be in a position to do that, right? Many a times when we see provisions like mandatory reporting, especially when they have, even a small period of punishment or imprisonment attached, we can feel the burden of that and feel that we need to go the extra mile to somehow satisfy this requirement. But as far as the law is concerned, you don't need to go to that extra mile. You do not need to take on any investigative function when it comes to finding out the quote unquote truth of the matter, whether it's the age of the child or whether it's the facts of the case in that sense, right? If a child makes a disclosure saying that I have, that basically the disclosure that conveys that sexual abuse has happened with the child, right? Then that is a different conversation, and we'll go through some of the mandatory reporting guidelines on how to respond when the child themselves is describing what is in fact sexual abuse. But if you are unsure, there is no obligation to try to investigate further, find out information about the child's sexual history or try to ascertain the truth of the child's age because you may not be sure. None of that is within the remit of your responsibility, right? So that's the first key case.
Hi, Saurabh. We are able to
Yeah, I
change the
think it's,
slides, right?
yeah.
Okay.
So now coming to the second case, this is slightly different from our first case. In the first case, as you saw, in the highlighted sections, what the court said was that the person didn't go the extra mile to, ascertain the facts of the case because that wasn't their responsibility. And so there is no violation of the mandatory reporting obligation on them. Now, in the second case, the case that you see before you right now, the court did in fact say that there was a violation. So why did the court say that, right? If you see this case is a situation where a medical practitioner knew of multiple disclosures of sexual abuse from 17 minor girls who were living in a hostel, right? They were basically being sexually abused by the hostel superintendent, and they informed the medical practitioner there that this has happened to us. The doctor concerned there, because there was a vested interest in protecting the superintendent, chose not to report. They did not choose not to report because they wanted to counsel the children or take them through the process of mandatory reporting or understand what some of their fears, their confusions may be. None of that was the criteria here. What this medical practitioner wanted to do in this case was specifically try to cover up something to benefit someone else, right? And so, because there was that clear intent, right, to violate the law, not just violate the law, but to actually not do justice by these 17 minor girls, to not provide them any access to justice, to rehabilitation, to care, to medical services, to mental health services, nothing. So, there was a direct attempt to cause effectively or aggravate the harm that has already been caused to these children, right? In that specific situation, you see how the Supreme Court responds. This is a relatively recent case of 2022. In that situation, they say nothing doing. We cannot allow this, right? And there has to be some accountability for the failure to report here because there was a malicious intent to violate the law, not to help the children, but to do more harm, right? Yeah, a continuation of the same case. And this is a direct quote from the judgment, and it really encapsulates what I was just discussing right now. That non-reporting of sexual assault against a minor child, despite knowledge, is a serious crime, and more often than not, it is an attempt to shield the offenders of the crime of sexual assault. So the court gave a specific context to when it believes someone might be failing their responsibility under this mandatory reporting provision. Another case, this was far more recent, a case as recent as 2025 last year, right? In this case, This was a case before the Kerala High Court. The Kerala High Court quashed all criminal proceedings that were raised against a doctor. Section 21 basically, like mandatory reporting under Section 19, Section 21 deals with those who are in charge of the institutions. So if a report is made to the person who's in charge of the hospital or in charge of the medical institution, then there is a additional responsibility on the head of the institution to report, right? So that's Section 21. So the case was whether or not that responsibility was violated. What the High Court said in this case was that the doctor did not have any knowledge, as a result of which they violated the provision. They had been informed by the child and their parents that they were not a child, that they were above the 18 years of age. And they took that disclosure at face value and proceeded to provide whatever services they need to, right? The court said that the doctor had no reason to question this. There was no obvious discrepancy in the age, where you're looking at a 12-year-old child and they're saying that they are over 18. There was no obvious discrepancy in that case. And so the court said that we find no reason to hold this person responsible. Now, why am I repeating this case as well? Because here again, the court reiterates what we said at the beginning, that there is no responsibility on a medical practitioner to conduct further investigation. Investigation is supposed to be performed by one group of people only, and that is the police. Nobody else has that responsibility, whether it's a school, a school principal or school staff, whether it's in the medical institution, whether it's the doctors. There is no responsibility to conduct an investigation of that sort, right? And that was something that the court repeated in this case. Yeah. So we'll move ahead now with this context, keeping in mind what the courts have said on mandatory reporting, what the law said on mandatory reporting, to now what are the actual concerns in implementing mandatory reporting and what are the guidelines that we've developed. I'll hand over the session to Sheila. Sheila, I think you can unmute yourself now.
Yeah, thanks, Saurabh. So the question is whether to report or not to report, frequently a dilemma for medical health and mental health professionals. So you have scenarios like this frequently enough. A child reports to you, begs you not to report further, says, I don't want anyone to know. I don't want even my parents to know, let alone the police, what would happen, etc. So that's the dilemma we are in. Just trying to move forward. Can I? Yeah. I'm not able to move the slide. Right. So there's a whole range of reasons why children don't want to report or adolescents don't want to report. There are family-related reasons. There are concerns about being believed. There are fears about making disclosures on so-called consenting sexual relationships. There's shame, embarrassment, a whole lot of taboos that our country still suffers from in relation to talking about sexuality. So, a bunch of reasons that I think we're all too familiar with. Next, please. Yeah. So, the purpose of mandatory reporting, as already explained, is that the offense must come to light, that the offender should be punished, that the child is safe, that there is no further offense by the offender. So the law in its own way is legitimate in having this provision. In fact, it's critical to have this provision. But we know, on the other hand, there are all these dilemmas where children and families are concerned. Next, please. And this is the balancing act that we are called upon to sort of maintain with the legal imperatives, the legal system, on the one hand, that pressures us to report, that says there are serious consequences to those who do not report, particularly health service providers and so on. And then there are children and families on the other, and their rights to participation, to make decisions, to actually provide consent for reporting, without which, may I just add, for all those who think that it's easy enough and we can just override the child's consent and go ahead and report, that becomes a moot point in itself, because let's say for a moment that we override the child's consent and we report to the legal system. Ultimately, it is the child who has to provide the evidence as per POCSO. So the child will be approached by the police and so on, and therefore, if the child at that stage refuses, to provide the evidence, or what we call as the child witness turns hostile and says nothing ever happened or doesn't wish to report in case of a consenting sexual relationship, then it doesn't matter what we say, the case won't stand. So mandatory reporting should actually be a gateway to other legal processes. So if the reporting doesn't work, that is, if we don't have the child's buy-in, it really doesn't matter. The mandate of the mandatory reporting law is actually not served, right? Fails in its objective. And that is why, moving on, we have developed, next please, you can move on. We have developed an 8-step guideline. This was developed by Samvad, which Dr. Galgali mentioned, by our team when we were working there, to look at how mandatory reporting could be done, should be done really, not as a one-off, simple, sort of straight up reporting. The child is reported to me, the law says this, and I should. You can do that because the law permits it. But because of all the dilemmas and challenges that I just mentioned, we have come up with a framework. We are possibly going to do a much more detailed session on this, but I'm just going to give you a brief overview for the purposes of today's session. Please note that we use these 8 steps of mandatory reporting processes with children who are 7 years and above, because children need to have the cognitive abilities to engage in the process. Children below the age of 7 are generally not engaged in this. Then we use similar steps to engage with the parents and families of these children in order to get what we call assent, right? That's parental consent. Moving on to the steps. Can you next, please? Yeah. So the first step is that we prioritize health and mental health. So mental health assessments, health interventions. It is far more likely that if we allow the child time to settle down, to be more relaxed, to recover from a certain degree of anxiety, that the child will be in a state to understand what the legal requirements are and then engage in processes to provide consent for reporting. And that's not the only reason, but one amongst many reasons why we prioritize health and mental health, apart from reasons of their own, of course. Next, please. The second step is about educating children about abuse. Now, in case of very young children, of course, they do not understand. They have no knowledge of sexuality, and there are many methods by which they have been abused, including lure and inducement and games, and this is our secret game, etc. So young children have no idea that this is a process of exploitation. Similarly, while adolescents have the knowledge of sexuality and so on, many of them may be groomed, right? So they may have very little understanding that what is happening is manipulation or processes of exploitation. And that's why helping children and adolescents first understand what abuse constitutes is the first step to begin the reporting process. Next. Providing children with information on the POCSO law, telling children in very simple language what the law entails, that there are rules in our country that people aren't allowed to hurt children, for instance, right? So that they understand why we are doing this. The fourth step, next, please, is to elicit and respond to children's fears and worries. What are their hesitations? Why do they not want to report? Every child has his or her own concerns about this. So it's important to allow children the space to articulate these concerns and to address them, not by giving false assurances like, oh, don't worry about it, but to find real ways to validate these fears and then to find ways to address them, to say that I would take measures like this, would this help, etc. The fifth step is to negotiate with the child, to essentially look at the pros and cons in a manner that is gentle, non-pressuring and sensitive, to look at what happens if you report. What happens if you don't report? What would be the benefits, the advantages, the pros and cons of reporting and not reporting? You're getting the child basically to weigh the pros and cons in order to make the decision, right? Moving on, step 6, it's important to explain if the child decides to report, what would happen. What are the legal processes that would follow? That the police would approach you, that you would have to go to court. All of this needs to be explained. It's only fair that children have the information of what would happen subsequently. Otherwise, children think that this is it. I've told you, and that's the end of it. And now you've told the police, and there ends the matter, right? So, this is why it's important to look at legal processes and inform children of the same. The 7th is on confidentiality. What this means is only the people who need to know will be informed, that is the police, legal authorities, etc. Children's worries are about, will my friends know, will the school know, etc. So that's what we mean by confidentiality. The 8th step is finally looking at whether the child is willing to go ahead with the reporting or not. Again, at this stage, we do not coerce the child. What is critical about this guidance is this, friends, that it is, as you see, a process. It is done over several sessions. And if at the end of session 10 or 11, when you've got to this step, the child says, no, but I'm still scared and I don't want to do this, or I really don't for whatever reasons, then you're going back to step 3 and starting from there all over again. So we may have to do this in cycles over and over till the child reaches a point. That is, if the child reaches a point to want to report or to provide consent, right? Next, please. Having said that, what about children who absolutely refuse? You've done all this work, you've tried, and this is where we do a risk assessment, right? The bottom line is that we move towards reporting. The intent is absolutely to report, right? But there are going to be several cases where children refuse. So, how do we do this risk assessment? If you look at what this slide shows, we ascertain high risk versus low risk, right? High risk is if the perpetrator has continued access to the child, regular easy access, and the abuse is still ongoing, and the child continues to be at high risk, and so on, right? That's a high risk situation. In such situations, you may negotiate with the non-abusive members of the family. You absolutely prioritize the child's physical safety over mental health or consent or participation or anything else, of course, and you override the child's decision and go ahead and report. Low risk is when the perpetrator is no longer present in the child's life, he or she doesn't have access. It was a one-off incident, happened a couple of years ago. The perpetrator was a stranger. The child doesn't even know who it was, in which case reporting becomes impossible. So this is how we do a risk assessment. And moving on. This is key to protecting you as health professionals. You need to document at every stage this conversation that you've had with the child, these 8 steps, the language you had it in. Presumably, it's the language that the child is familiar with and speaks fluently. The date, the language, what information you gave, what you said, what you asked, what the child's responses were, and what the child's reservations were, and to maintain this documentation, to file it and keep it, so that if ever you are asked by a court of law, and that says, why didn't you report, you show intent to report. And that is what protects you, right? So that is on mandatory reporting. Let's park that as part of what you need to know as we move on to the issue of adolescent consent and underage pregnancy. Saurabh?
Yeah, before I move on to the issues of adolescent consent, which we'll discuss briefly, just to also remind everyone something we discussed before. Sheila took us through the mandatory reporting guidelines. That documentation imperative at the end is the only way in which you're able to differentiate your intent versus someone else's intent who is seeking to cover up a case or is not reporting for other kinds of reasons, right? The reason we say document is because that documentation helps show that you were basically working with the child to report, but the child had issues and you were working through those issues with the child. And so if you notice what we said on the slide also, we said that what your documentation reflects is that the child is not ready to report at the present moment, but that when they are ready to report in the future, you will certainly facilitate their reporting or they can report themselves, right? The reason that exists as a possibility is because POCSO does not require anyone who's reporting to report within a specified timeline. POCSO Act does not say that if you find out information, you have to, as a medical practitioner, report within 24 hours to the police. That's not there, right? And so because you have certain time and the act does not specify any, specific schedule like 1 day or 1 week or anything of that sort, you're able to treat mandatory reporting as a process, right? And that's also part of the reason why anyone can file a POCSO complaint about something that has taken place many years ago in their lives. As long as it's after 2012, which Shubham mentioned earlier, it doesn't matter how many years later you decide to report. Right? So there's a couple of things to keep in mind. Now, moving on to the issue of adolescent consent, right? Two separate scenarios, just very briefly want to go through with you. Right? One, we have a situation where a 16-year-old is in love with a 30-year-old man, elopes with this man, right? What is the child's wish and decision here, right? Could we call this consent? In scenario two, you have a 16-year-old and a 17-year-old girl and a 17-year-old boy who are in a romantic, mutually consenting relationship, right? Both are adolescents, similar in age, and they decide to continue this relationship. Now, technically, both cases, the claim of consent is being made, but if you actually examine it, the dynamics of consent, understanding, and a relationship between a 16 and a 17-year-old vis-a-vis the dynamics of consent between a 16-year-old girl and a 30-year-old man are quite different, right? In the case of the 16-year-old and a 30-year-old man, the 30-year-old man has far different capacity for consent. This is a fully grown adult, right? Has significant power over this child in this relationship, right? And is in a perfect position to groom and manipulate the child into believing they consented. And that's what we call manufactured consent or grooming, right? And so that can present itself like consent. But from a developmental standpoint, since we all of you are medical professionals yourselves, you probably are not inclined to call that consent because the child does not have the same resources, knowledge, understanding, and capacity as this 30-year-old man. When we're speaking about a 16 and a 17-year-old, though, they both are developmentally vulnerable. They both, of course, have deficiencies in terms of their life skill deficits, but there is no power dynamic there. There's no case of exploitation, at least in this scenario, right? Where it is a mutually consenting relationship. You could also have a third scenario where you see a case where a 17-year-old girl who might cause abuse of 14-year-old boy, right? So there might also be factual cases where even though two adolescents are not significantly different in age, there is the facts disclosed to us that there is a case of coercion, manipulation, grooming, whatever, right? But that depends on the facts of the case. If you have a situation like scenario two where it's mutually consenting, then we don't treat it in the same way, right? And so when we speak about consent, it's important to distinguish all three of these kinds of cases. Yeah. And just very briefly want to go through, we've spoken about a few scenarios, but very briefly want to go through some of the current dilemmas, right? What are the dilemmas? The dilemmas essentially relate fundamentally to the age of sexual consent under the POCSO Act. Now, the POCSO Act tells us that a child is anyone under the age of 18, but it does not give us a minimum age, right? Where they say that a minimum age is decided post which someone has the capacity to provide sexual consent, what we call the age of consent. In many countries, there is an age of consent that is also specified in the law in addition to mentioning who's a child and who's an adult, right? And that clarifies what is the minimum age at which someone has the capacity to provide sexual consent. In India, as per the POCSO Act, there is no such age. And so what we are left with is that anyone under the 18 does not have, is presumed rather to not have the capacity to consent. And above 18, it becomes a case of, the facts of that case. And that's where we have this issue of criminalization, right? Where unfortunately the law is not only applying to cases of exploitative sexual behavior, but it is also unfortunately, applying to cases where there is no exploitation, right? It is between two people of similar or same age. But because the law does not recognize the capacity for sexual consent, they end up becoming criminal offenses. Also, because of the context of patriarchy and the manner in which our criminal laws are implemented in India, this means that typically in a consensual case, the boy is presumed to be the offender while the girl is presumed to be the victim, right? So even though there is no offender or victim in a consensual case, the law takes its course because it is implemented with all of these biases, right? It is implemented by people at the end of the day. And that results in adolescent boys in consensual cases being exposed to very serious criminal consequences, right? So when we speak about consent, we keep in mind this larger context of the dilemmas under the law, the issues with adolescents. And now I want to move towards a very important case that came about a couple of years ago that basically dealt with issues that we've just discussed in terms of adolescent consent and mandatory reporting under the POCSO Act, as well as what you all know perhaps briefly about the Medical Termination of Pregnancy Act, right? The legal means of abortion in India, right? Now, why did this come up to the court? The principal issue here is that the Medical Termination of Pregnancy Act, which Shubham will briefly go over with us, requires maintaining confidentiality and privacy. And the POCSO Act, on the other hand, says you must always report, right? So there are two provisions that are directly in tension and in conflict with each other. So the court was basically asked, how do we have both laws? How do we interpret both laws in a harmonious way so that they are not in this kind of tension with each other, right? And what the court did was basically to first, we'll come to what the court finally said. It first said that, we cannot disregard the truth of adolescent sexual activity, right? It is part of their normal developmental trajectory. Whether we consider it an offense or not is not going to stop it from happening, right? And it also says that it could not have been, the view of parliament to basically not provide safe abortion services even to adolescents, right? Ultimately, the act is supposed to help all vulnerable women, including adolescent girls, right? So that's the first thing that this specific judgment said. The judgment in itself was called X versus Principal Secretary, as you can see on your screen. It is very important because it helps basically read both these laws together. Right. The first part that I want to focus, in addition to what I just mentioned in this judgment, is how it looks at the issue of reproductive autonomy, right? The code basically in this says that reproductive autonomy has to be looked at in a broad sense. The idea that someone should be able to make a choice about whether they are able to go ahead with this pregnancy or not, depending on certain circumstances, right? So the law depends, and the way the court interpreted the law was to say that there might be situations in your life that change your circumstances significantly. In that situation, the person should have the choice to decide whether to go ahead with this pregnancy or not. Why? Because that liberty is part of their right to life, which is also a constitutionally protected fundamental right as well. Right? Related to this point about reproductive autonomy, right, was the question of access. And very importantly, you can see the part that's highlighted in the slide as well. The court said that the Medical Termination of Pregnancy Act, our abortion law, recognizes this reproductive autonomy of every pregnant woman, right? What it goes one step further to say is that this right also extends to a person accessing healthcare facilities to attain the highest standard of sexual and reproductive health. So it's not limiting access to just accessing abortion services. It's also saying that access means accessing sexual health related services, which include a whole range of services, including information about sexually transmitted diseases, information about sexual intercourse, access to contraception. They would all come under access to sexual and reproductive health, regular medical checkups, right? All of that would come under this, right? And it said that if we are talking about reproductive autonomy, then access to all of this has to be provided. Now, coming to the last important bit that the court said on this specific issue, right? How do you read both these laws together? What the court basically did was that to say that if a adolescent girl and a guardian approach a medical establishment to get the abortion, to get the pregnancy terminated, right? And they do not want the details of the girl to be disclosed because it'll turn into a POCSO case, right? They just want access to abortion service. Then the medical practitioner, the doctor in this case, can withhold the personal details of the girl, her family, basically any identifying details, and simply say that on the 3rd of February at 9:15 p.m., we received this request to conduct abortion services on a specific date. The next day, the medical termination was scheduled, the procedure was initiated, right? So basic details about the age of the person, the time they access to the medical institution, but no identifying details because the adolescent girl and their guardian did not want that disclosed. So what this does is that it fulfills it is essentially a compromise of sorts, right? It fulfills the reporting requirement of the POCSO Act, but it also protects the privacy and confidentiality of the adolescent girl as well as the guardian, right? In the situation. So that is kind of the balance that the court came to. The court also said that at no point in time, if there is a case, for example, if the police register an FIR, the doctor cannot be called to court to and be asked to disclose the details of this adolescent girl or her guardian. The doctor at no point of that case can be called and made to disclose any details about this person because they have chosen not to disclose their identity, right? So this was a very important case, as you can imagine, because the goal of the court was to facilitate access to abortion because one of the significant causes of death in India are cases of illegal abortions that are not done in capable medical facilities, are done, by quacks, by non-medical professionals, right? And that has a high fatality rate. So the goal of the court here was to ensure that people do not go there. They access genuine abortion services, genuine medical facilities, right? And also ensure that they access because this fear of reporting doesn't exist now, right? Because they are not required to report. Right? So I've discussed, broadly what this means for you, especially in the context of abortion services and reporting, right? And how do we actually see this entire sort of consent issue? How do we see access to reproductive and sexual health services, when to report, right? Sheila also went through the 8-step mandatory reporting guidelines, right? And how to undertake a risk assessment, basically to know when to report, right? So you have reporting in a general sense, and then you also have cases specifically dealing with pregnancy and access to abortion services. Right? A key part of this, also part of the access to reproductive health and services, is ensuring that every child is informed of their right to access medical termination. Many times, medical termination is not done because the child is not informed of the right. Right? And this is a key bit of information that should be provided by medical practitioners. Right? This again is a situation what the court said. I'll go through it very briefly. One, relating to the change in circumstances I spoke about earlier, right? If there is a change in circumstances, the court allows the person to make a decision about whether they want to go ahead with the pregnancy or not. So refugees or people in humanitarian disaster, right? Things can change, plans can change, financial ability can change, and therefore they should be in a position to reevaluate the choice. Similarly, in the case of abandonment by the partner or death of the partner, right, or abandonment by family, again, that is a material change in circumstance. So there as well, the court said that the person should be able to decide differently. Again, related to the same point that we discussed about change in circumstances and the choice the person has to continue or not continue with this pregnancy. Right. So let me move ahead now and hand over the session to Sheila to basically go through certain key imperatives again related to our discussion on adolescent sexuality.
Yeah, so this is just an aside because when we think about adolescent consent, right, we have a whole lot of other thoughts that go through our minds. Do they really have the right? Do they need to be engaged sexually? Are adolescents allowed to gratify them? Now, we may all have a range of personal opinions on these, and these opinions are varied. They're based on our own backgrounds, our value systems, our own concerns, etc. The point is, friends, that adolescents are going to engage sexually for reasons of neurodevelopment, for reasons of normative development. No matter how hard we preach abstinence, it really isn't going to work, right? Moving on. Can you? The other thing to remember is sexual decision making and the issue of consent, therefore, just an age related issue? To give you a very simple and an obvious example, if you're 17 years old today and you turn 18 tomorrow, does it mean that at the stroke of midnight you're a different person? Your thinking magically changes. You magically develop these amazing capacities and this wonderful wisdom to enable you to do what you couldn't do just a few hours ago? Not really. So really, age is but a number. There are other skills we are looking at for adolescents to be able to develop the capacity to consent, to have the competencies required to make decisions in sexual contexts. Moving on. And just very briefly, we do a lot of work in the area of life skills, as Dr. Shekhar mentioned at the outset. When we work with life skills in the context of sexuality with adolescents, we are looking at several factors. And we work with adolescents to understand each of these 6 parameters or factors so that they can use them in decision making. So the first is acknowledgement of emotions, that it's valid, that you have the right to desire, to want to engage sexually, to experiment. So we acknowledge curiosity, love, attraction, and all the emotions that puberty and adolescence normatively bring. But the point is, how do we ensure that they have sexual relationships that are happy, healthy, safe, non abusive, non exploitative? That really is the concern. And so we discuss several other parameters that you see there: privacy, where, when, consent and boundaries. What does consent mean? What is mutual consent about? What if someone says no and doesn't give permission? How do we proceed then? Relationships, who's the person? Is this a cousin, an uncle, a family member? That might be a problem. Is this a friend? Is this a 5-year-old child that you wish to experiment with? So we are looking at relational contexts in which it is safe or unsafe, as the case may be, to engage sexually. Health and safety, that is where pregnancy, HIV, STDs, the whole gamut of health and disease comes in, condom use, and so on, what safe sex means. Abuse and protection, which goes back to what I said under mandatory reporting. What do they understand about abuse? Do they understand what abuse and exploitation constitutes in order to be safe from it? And finally, of course, one more factor that we discuss is the law itself. What the law says about 18 years of age, etc., what it says about marriage, and so on. So that children have the kind of information, knowledge, as well as skills to think through, based on these factors, how and when to provide consent. So this is, and this kind of life skills work is not done through a lecture and just information giving. We do a lot of films and art, and through games and music and so on, we get them to take positions, take perspectives. So life skills education methods entail a process of reflection, essentially, where we get a group of children ideally, but it can also be done with a given child, to engage in the process of reflecting, of re-examining positions or understandings they may have, and to take perspectives that would enable them to be, as I said, safe, happy, healthy, and responsible as they engage in sexual relationships. Let's move on. So that was the psychosocial perspective on adolescent consent. Just to tell you that there is the legal part, as Saurabh discussed, health information and so on, all that the law now says that adolescent reproductive health services are a must. And just because we are not able to, in certain instances, follow through with the mandatory reporting clause immediately, it doesn't mean that we deny them of services. These health services also encompass mental health interventions, basically life skills education, as I just mentioned. And here's the last bit of our talk on medical termination of pregnancy to tie up the other concepts.
Thank you, Sheila. Just as an addendum to what Saurabh had earlier discussed about the MTP in the context of underage pregnancies, we would just like to provide you with a little bit of more jurisprudential evolution and clarity around who is a woman who can seek termination of pregnancies, particularly if they have if their gestation period has increased by above 24 weeks, or they are victims of sexual assault or rape. So what the MTP Act essentially says that the first thing that we need to remember is that any woman, right? And this is any woman can access the MTP in order to go ahead and get an abortion done, right? However, if this woman is under the age of 18, i.e. that they are an adolescent / a child, they need permission from their parents. So the consent of the parents or the legal guardian is also required to undergo an MTP, right? However, for any woman above the age of 18, that parental consent or that guardian consent is not required. There are three separate categories of termination of pregnancies as envisioned by the 1971 MTP Act, right? The first is any pregnancy which is below 20 years or 20 weeks, right? For such pregnancy, we just need the person who seeks MTP only requires the opinion of one medical practitioner, registered medical practitioner, and they are able to go ahead and get the MTP done. For all women who seek to take MTP or seek to access MTP between 20 to 24 weeks of gestation, they have to go ahead and take the advice or the clearance from two registered medical professionals or practitioners, right? However, earlier, before the next judgment, which we'll be discussing with you, what the norm and the norm was that any woman who sought MTP beyond 24 weeks of pregnancy had to go ahead and take the state medical boards and approval and certification in order to go ahead and get the MTP done. And when did the state medical board go ahead and grant permission to undergo an MTP? The only condition that was available to women was substantial fetal abnormalities, right? So it did not matter if this victim was a survivor of rape or child sexual abuse. If the progeny, if the fetus does not have any substantial abnormalities, they were not allowed to undergo MTP by the state medical board, right? As you can understand, this was a grave injustice, particularly for those victims of sexual abuse, who because of various barriers to reporting and disclosure that Sheila had already alluded to, could not go ahead and seek MTP in a timely manner, right? So therefore, what the Supreme Court recently tried to achieve is that it said that for all women who, including minors, right, who have been sexually abused, for all such women who wish to go ahead and avail an MTP, they must now, beyond 24 weeks of pregnancy, now the medical board has to not just look at whether the fetus has any substantial abnormality, but the medical board has to also equally evaluate if there is any physical or emotional harm that can be caused to the pregnant person in terms of its own judgment, right? And both of these evaluations need to be equally weighed. And if in case there is no substantial fetal abnormality, however, there is physical and emotional harm that can be caused by taking that food pregnancy until completion, then that pregnancy can be allowed to be terminated by the state medical board, right? Constituted under the MTP Act. So this actually goes ahead and brings forward a new era of understanding, or no new era of understanding in the context of reproductive rights. And I think combined with the judgment that Saurabh had already discussed when he was discussing the disclosure of identity and the requirement therein in X versus Principal Secretary, we can now see that reproductive health and access to reproductive health has had a substantial shift, in which now we consider the right of the pregnant mother way more seriously and way more gravely than what we used to do early, right? So this right extends not just to their own physical and mental well-being, but also extends onto their consideration of privacy and the right to privacy that they have as well. So I think that basically goes ahead and provides an even more comprehensive perspective on the MTP law as we understand it today. Sheila, if you'd like to go forward. Yes, Saurabh, I think you have to unmute Sheila. Yeah.
Yeah. So just a couple of final thoughts. What is important is preparing children for medical interventions, whether it's an MTP or a gynecological examination that you're going to carry out, or a post-abuse examination, or examining the child post engagement in sexual behavior, etc. This is just an example for script, what you see here, in terms of what to tell the child. Very often, children are anxious. They refuse to let you examine them because they are worried about the consequences. They're scared of what will be found out, who you will tell, and what might happen. So, in providing reproductive health services to adolescents, it is important to give them a context, reassure them that all we are doing is, when one has engaged in a sexual relationship, sometimes in unsafe circumstances, whether it is in the context of consent or not. Testing helps us look for certain infections, and all we are trying to do is to treat them. We tell children that the thrust of this is to look for injury and disease, and that the sooner we do this, the safer it would be, and so on. You may want to discuss what you're going to do, inform the child what kind of tests will be done, what the possible consequences could be, and how you will deal with them, so that the child feels reassured that there's a solution. There are fears very frequently of pregnancy, and that's why adolescents don't even want to do the tests, and so on. We say this in the context of the fact that we've had cases where children have actually engaged in self-harm and suicide behaviors out of severe anxiety when they know that they're being sent for medical examination and interventions. That's why preparing children is absolutely critical. Moving on. what was mentioned earlier as well, while of course people above the age of 18 or women above the age of 18 have the right to choose, and the Supreme Court has strongly and clearly articulated that with their MTP decision. For those of us who support rights based practice, we also have discussions with adolescents on whether they wish to go ahead with the MTP or not. That cannot be an assumption or a presumption that, if they've had sexual intercourse and have become pregnant, that they absolutely would not want to keep the child. We have had many instances where adolescent girls have wanted to keep the child. Again, we do a lot of work in this area to train people on how to have this conversation, essentially to discuss with the child her reasons for wanting to keep the fetus, to continue with the pregnancy, to discuss pros and cons, finances, logistical plans, her dreams, her plans for education, how these fit if she indeed wants to continue with the pregnancy. Ultimately, for those of us who are child rights activists, it is the adolescent's decision to go ahead with it. We also offer other options about putting the baby up for adoption, etc., in case she were to change her mind at a later stage. Moving on. So, just to highlight here the challenges of working with adolescent girls, a lot is often said about adolescent boys, especially when they come in conflict with the law. And but the same applies to girls in terms of brain physiology, neurodevelopmental vulnerabilities, the impulsivity and emotionality with which they make these decisions are very much true even in the pregnancy context. There is difficulty with future orientation. There is a romanticization, certainly, of pregnancy, of wanting to keep the child. But even so, we do the work, and sometimes, we have permitted adolescents to proceed with their decisions. These are gray areas of our work with adolescents, but that's where we are. So I just wanted to highlight that. And I believe, next, please. In conclusion, these are some take home messages of the long story we've told in different parts. The first is to acknowledge normative development and neurodevelopment. As I said earlier, also, adolescents have the propensity, whether we like it or not, to engage in high risk behaviors, including sexual behaviors. Abstinence has never worked, friends. There's plenty of evidence to show that programs that have tried to promote abstinence have failed. So I don't think we have too many options, but to help adolescents to make safe choices as they continue to engage in what they absolutely will, to take a rights based perspective to reproductive and sexual health, to not look at sexual behavior as a purely age related issue in case of adolescents. This does not apply, of course, to children. To not deny reproductive, sexual health, and mental health services to adolescents just because of reporting issues. And now you have that from the Supreme Court itself. That mandatory reporting is a process, not a one off act. And therefore, we have time, as you have seen, to do it. There are processes to be followed. But in the interim, we carry on with the reproductive health and mental health, life skills, education services that we need to provide. Indeed, other countries are doing it this way. I did see a couple of questions on whether it's okay to provide contraceptive advice to under 18s. Absolutely, we must do it, because if we don't, the consequences, I think, are far worse. And if you look at the NHS, you look at the systems in the UK, in the US, and so on, adolescents are free to go and get reproductive health advice, to get advice on contraception, sexual behavior, etc. And we are recommending currently to the Supreme Court in the PIL response that Dr. Shekhar just mentioned a little while ago to do the same. That India has to move in that direction as well. So those are some take homes, and we've tried to answer as many questions, Dr. Galgali, as we can on chat, knowing that we may be out of time, but we are happy to, stay on and take questions in as much as you have the enthusiasm and energy for. Thank you.
Um, Dr. Gargali, I just wanted to briefly, in addition to what Sheila mentioned, respond to a couple of the questions, just as a couple of quick follow-ups. One, I think there was a follow-up in regards to the question on providing contraceptive advice to an under 18 adolescent girl. And I think the follow-up question was, but what if a sexual act follows the contraceptive advice that we give? Will that not become a POCSO case? Right now, as with anything on the POCSO Act, if you saw the thread of what all of us were discussing today, it is important to be tactful, right? How you give advice is very critical and almost as critical as what advice you give. Now, I can give advice to say that, this is what you need to know about contraception. This is how safe sex works. But please know that the POCSO Act treats these kind of sexual behaviors as criminal, and that's something you have to keep in mind because there can be severe consequences. I'm giving you this information because it is important information for any person to know. That's one possibility, right? The other is to provide advice without any kind of context. So advice can be given, and providing advice in good faith in a tactful manner does not result in penal consequences, especially when the advice is related to contraception. As Sheila mentioned, that is a imperative part of access to reproductive and sexual health services, and absolutely has to be provided. There was also a question on very quickly a question on 17-year-old and brings the 18-year-old partner to basically seek termination of pregnancy. Unfortunately, if the 17-year-old does not receive consent from the guardian, they will not be able to go ahead with the termination of pregnancy. The medical practitioner would not be able to sign off on it because they need the guardian's consent. What you can do there, though, is to try to speak to the parents, try to follow up with the guardian to say that there is this imperative now, whatever your beliefs or your thoughts on the relationship itself, this is going to have lifelong consequences. You need to listen to what this adolescent girl wants because she has to live with with the choice that you make or the choice that gets made for her by virtue of time. Right. So that's one way to approach it, but you cannot go ahead with the medical termination without the guardian's consent. There was also a question about an interesting question about what happens when a quack, one of these, kinds of quacks, try to do a medical termination of pregnancy. It goes awry, and then it comes to the hospital because of severe injuries and so on. Absolutely, immediately report it to the police. Right. That is a grave case of medical negligence. There should be no delay at all because it's not just a question of the child's health and the fact that the fatality rate in those kind of cases is incredibly high, as most of you know very well. But also the quack itself, if they're not held immediately accountable, they'll probably continue providing these kinds of illegal services to multiple other people and probably continue to put other lives in jeopardy. So immediately report because it is a serious case of medical negligence. So that was just a few responses. Yeah.
Thank you so much, Saurabh, for quickly answering so many questions. Really appreciate that. I just had one more question which was asked. So when we are, following the process of mandatory reporting, the a patient does not turn up for the next visit, follow-up visit. Though we have documented the first visit and there is an intention to report, what do we do then?
See, one of the things here is it's a very difficult situation. The law mandates that we inform the child, adolescent family, that, at a first instance, there is a law. But I think a lot depends on what we convey about the law at the beginning. If they are told that, I also want to tell you that there is a law and we will have to report. So I'm just letting you know right now. And then they get panicked and decide never to come back. That's one way. But the idea is to take a relaxed stance to say, I want to inform you there is a law and this is what it says. But you know what? The good news is that we can take our time to report. There are a lot of things to discuss. And we don't have to, go running to the police station like now or tomorrow to report. So let's park it. We're going to come back and talk about it. Let's first look at, how you're feeling, other things we have to do, medical interventions. I know things have been difficult and confusing. So if we were to do it that way, the chances that we will hold on to our client at least long enough to be able to deliver the medical and mental health interventions are much higher. So that is the way we have always approached it. But I think Dr. Shekhar may want to come in on how we always prioritize. And now the Supreme Court has clearly, I think, said it to help us to prioritize health, medical services, and mental health services always over the law. I think the court has also realized that health is going to be more important always than legal reporting. So I think we can hold this higher than reporting. I don't know, Dr. Shekhar, would you like to say something on this?
Yeah, I just like to give a few closing remarks so that Dr. Geeta Bansal's statement about excellent time management is not refuted by us taking too much more time. I see that there are a lot of questions pertaining to the whole MTP conundrum, which has been reasonably ordered. This is an order passed by the former Chief Justice, Justice Chandrachud, saying that offering reproductive health services is the right of a person of whatever age. All you need to do is report that you've done an MTP. You have no obligation to give the name or the identity of the person. The second issue is that I've seen a couple of statements that some of the issues were kind of too theoretical. Unfortunately, the person who put the statement dropped out of the webinar. I just wanted to say you need to know the law and the provisions of the law. That theory is important because in the absence of that knowledge, you'll be floundering, which is why we followed up the session by giving examples of how it plays out, by giving various case scenarios. It's unfortunate that the gentleman in question dropped out of the webinar and was not patient enough to wait for the fact that we were going to speak about these issues. So the sum in total, and I've answered many people their questions to them individually. A lot of issues, pertain essentially all the hesitancies and resistances ultimately boil down to one fact: there is no time limitation to mandatory reporting. So please rest assured that you have no obligation to report within a certain period of time. As long as your intention to report is documented, you understand the fear, the concerns, the hesitancies, the terror of the family, and address it. And the issue of a risk assessment. Now, if a child or a family tells you that I'll kill myself or there is mental health morbidity, it is your obligation to prioritize health and life over other considerations. So you'll document it to say, I've done a risk assessment. At this point of time, the mental health morbidity is very high. However, I have informed them about the law. There is no pressure, and we will do it at a point of time where there is no risk to life and no risk to mental health. The thing is, in the history of POCSO, I was on the drafting committee, so I'm telling you, not a single medical professional has been prosecuted for so-called failure to report or non-reporting. So my question is, what are we agonizing about? That is why we have presented a robust frame of reference for you to keep in mind where you reconcile POCSO with the changes that have occurred in the MTP law, particularly after the Honorable Supreme Court's judgment, and more than anything else, with the recent Nipun Saxena case and the interim affidavit that we have filed to really look at not criminalizing consenting adolescent relationship, brings me to the last point which someone raised. It's an interesting question because it's really the dividing, the sort of cutting edge between good practice and ethical dilemmas. But if we give contraceptive advice, does that not mean that we are encouraging sexuality? And if someone actually engages in an act, doesn't it come under the purview of POCSO? Now, the thing is, that's an obverse logic because 16, 17 and a half year olds are in any case engaging with intimacy and sexual experimentation. The risks, and this is what I said initially when there was resistance to our doing work on child sexual abuse. The government of India adolescent reproductive sexual health program was trashed by 17 state governments saying हमारे बच्चों की इसकी जरूरत नहीं है, you'll be making them perversely, curious and all that. And I had only one thing to say at that point of time. If you think information is a problem, try ignorance. How can information be more of a problem than ignorance? It is so good information, nuanced information, and the window that Sheila presented is how you lead to healthy behavioral choices, healthy sexual choices, and all the other issues. If a girl takes an MTP pill and comes in shock, if an incomplete NTP has been done, if a 17-year-old hasn't informed the family and arrives for an abortion, do we need consent for MTP and so on? All of this is essentially covered, and it addresses the issue which I see now. What if the patient doesn't come back? Now, dropouts is not particular or peculiar only to this issue. People drop out of treatment all the time. You all know that. So this is what I think is finally endorsed by the many comments that are coming now. Very useful session. Share the link. Learn to talk today, and so on. And finally, of course, in protecting the rights of this baby, what do we do with the baby when the adolescent mother refuses to take the child? Is there a family involved? There is the child welfare committee. There are issues where you can put the child, and this is exactly what Sheila said, both about whether to go ahead for abortion or not, or if a child is delivered, what are the circumstances, and, does this 16, 17-year-old or their family actually want, is this a child born out of sexual assault and rape, or was this a consenting relationship, and so on. So these kind of considerations for those of us who are deeply interested in social pediatrics, as I'm absolutely convinced the 100 of you who have still stayed on this session are. You're absolutely, I think, devoted, dedicated, and committed to social pediatrics. And I think this is the direction. All of you are excellent in managing your nephrotic syndrome and your childhood asthma and your SAMs and malnutrition and fevers and all of that. I'm absolutely convinced that you're stellar professionals. But I think that the whole ideology and philosophy of the Adolescent Health Academy is to look at social aspects of adolescent health. And thank you very much. And we will have further discussions with Preeti and the rest of the team at the Academy to see how we can curate further sessions to make it meaningful in your practice, and meaningful both at an ideological level of medical practice, binding together the two tracks of ethics and of medical practice. So thank you very much. Preeti, you're on mute.
Thank you, Saurabh. Thank you so much. Thank you. So that was fantastic. So a right-based approach to form healthy, safe, happy, responsible relationship in adolescent is our mantra. And I would now request Dr. Deepak Gautam, the treasurer of Adolescent Health Academy, to give a word of thanks. Saurabh, you'll have to unmute Dr. Deepak. Deepak's iPhone, it comes by that name.
Thank you,
Yes.
ma'am. And first of all, I congratulate for such a wonderful webinar. And then I, Dr. Deepak Gautam, on behalf of AHA, thanks from the bottom of my heart to all the participants to make this webinar such a great success. And special thanks to Dr. Preeti for facilitating such a topic which is a need of this time. Dr. Sushma Desai for taking this initiative. Dr. Shamik for conducted such a wonderful program. And also the faculty, all 4S, 4 stars, Dr. Shekhar, Sheila, Shubham, and Saurabh. And all the participants, thank you very much. And on the last, I very special thanks to Azim Premji Foundation for organizing such a wonderful program. Thank you very much.
Saurabh, will you unmute Dr. Sushma Desai? I think perhaps she wants to say something.
Yeah, thank you, Saurabh, for unmuting me. And sir, it was a very, very insightful discussion, and we all enjoyed. I think there was not a single moment which was kind of, uninterested or something like that. It was extremely interesting and very, very practical. So we look forward to many such webinars, and we do look forward to how to counsel the cases when they come with such things. So that will be a kind of very practical aspect of handling adolescents with sexuality issues. So, sir, this is what our, I think. Yes, sir, please. Sir, you said something. Yeah, so we look forward to having many more such webinars, sir. And it was such an excellent webinar and very, very uniquely, I would say, composed and delivered. So this is what we would love to have, sir. And thank you so much, Dr. Sheila, Dr. Saurabh, and Dr. Shubham for very, very insightful, informative, and I would say practical discussion. And that is what we need. Thank you so much for clearing so many fundas. Thank you. I think Dr. Preeti ma'am, is that should we conclude the session? Preeti ma'am, and sir, we would like to have the rest of the programs. Ma'am.
Sure.
We'll talk about it. We'll talk about it, Sushma. Yeah.
Wants
Yeah,
to
we'll talk
get
about it.
unmuted.
Yeah.
Sure. Thank you, sir. Thank you so much.
Good night.
Good night, sir. Good night.